Chapter 3, Unequal Treatment of People with IDDD under State Guardianship Law, page 39. At the center, California, Connecticut, Idaho, Michigan, and New York have separate guardianship statutes for people with IDDD versus those with other types of disabilities. IDDD-specific state guardianship laws. Most states have a single guardianship law that covers people across disability categories, including older people with progressive cognitive decline, people with mental health disabilities, and people with IDDD. However, as recognized in the 2018 NCD report, there are states that have different statutory procedures, standards, and processes for appointing guardians for people with IDDD, as compared to other populations that may need guardians. A list of these states and the main ways statutory distinctions apply to people with IDDD is available in Appendix A of this report. Existing scholarship has mainly focused on the IDDD distinctions in 5 states: California, Connecticut, Idaho, Michigan, and New York, which have separate guardianship statutes for people with IDDD versus those with other types of disabilities. On paper, New York's statute is one of the most striking. New York maintains 2 separate systems of guardianship for people with disabilities. For example, Article 17A of the Surrogate Courts Procedure Act for the people with developmental disabilities and Article 81 of the Mental Health Hygiene Law for all other people. Under the former, the basis for appointing a guardian is driven by diagnosis rather than functionality. It also has less rigorous procedural requirements than Article 18 of the Mental Health Hygiene Law. For example, a hearing on the guardianship petition is not required. The person with a disability does not have to be present. The guardianship cannot be limited, and guardians' decisions are based on a best interest rather than a substituted judgment standard. Additionally, unlike many other statutes, New York's statute allows a guardian appointed under it to make any and all healthcare decisions for the person with IDDD. On the other side of the spectrum is Michigan, which has a guardianship statute for people with developmental disabilities that generally provides them with more statutory safeguards than people without such disabilities. For example, the Michigan Developmental Disability Specific Guardianship Statute requires that guardianships be limited in scope to only that which is necessary because of the person's actual mental and adaptive limitations. Partial guardianships are preferred but not required, and terminate after no more than 5 years. Page 40. Apart from those states with entirely separate guardianship laws depending on a person's diagnosis, there are other states that make other kinds of distinctions for people with IDDD, as indicated in Appendix A. For example, some allow for a governmental agency or representative to be appointed guardian of a person with IDDD. For example, Hawaii, Minnesota, and South Dakota. Or others require additional court determinations, for example, Iowa, with respect to voting rights, or clarify that an IDDD diagnosis alone should not govern the scope of a guardianship, for example, Arizona. As discussed in the 2018 NCD report, some states have so-called alternatives to guardianship that are essentially still guardianships. For example, Florida has a legal process for guardian advocates that is referred to in its statute as a less restrictive alternative to guardianship and is only available to people with particular developmental disabilities. Rather than requiring Florida's standard determination of incapacity by an examining committee of experts, the judge, who may not have any expertise with disability, may use educational evaluations, IEPs, and other support plans to determine whether the person has the capacity to retain at least one right, but needs a guardian advocate appointed to exercise other rights. If so, that guardian advocate will essentially have the duties and responsibilities as a guardian under Florida law, without the person having the same due process safeguards. Another example of the way in which some states relax due process protections for people with IDDD, both expressly and indirectly, can be seen in Utah. Utah's law does not require a court visitor to investigate the appropriateness of appointing a guardian. If the person involved has an intellectual disability or an intelligent quotient score under 25, which on its face would appear to discriminate against people with certain IDDDs, Additionally, in 2016, the Utah legislature passed a law that created an exception to a person's right to counsel when facing a guardianship petition. While not specifically referencing people with IDDD, this law change made it easier for their parents to obtain guardianship over them and further bolstered the school-to-guardianship pipeline. The law was focused on the approximately 300 cases per year where parents seek guardianship over their adult children with disabilities in Utah state courts. It eliminated the requirement that adults with disabilities have their own attorney when their parents petition the courts to be their legal guardians. Their assets are less than $20,000. They appear in court with the petitioner, and they are given the opportunity to communicate, to the extent possible, the person's acceptance of the appointment of petitioner. In July 2017, disability rights advocates filed legal action in federal court challenging the law on discrimination grounds. In May 2018, the Utah legislature amended this law to limit the applicability of the exception to the right to legal counsel and to require that, when it does apply, a court visitor, such as a social worker, be appointed to investigate and report to the court. In November 2018, the federal court lawsuit was settled. As part of the settlement, the Utah Administrative Office of the Courts and the Utah Judicial Council agreed to strengthen legal protections for adults with disability in guardianship proceedings by ensuring judges are informed about the importance and availability of legal representation in such proceedings. First, explore less restrictive alternatives and consider full guardianship as a last resort. Page 41. The excerpt at the center says, "The manner in which guardianship plays out for people with IDDD has little to do with how the actual law is written." However, Utah's exception to the requirement of legal counsel in cases where parents are seeking guardianship over their adult children remains on the books, albeit in a modified form. The impact for IDDD guardianship statutes on people with IDDD and U.S. policy. Stakeholders in the affected states express varying knowledge and opinions of the impact different statutes have on people with IDDD. One family member in Michigan, who serves as co-plenary guardian for her two sons with IDDD, felt that the separate IDDD law was a good thing because she saw the problems with guardianship as varying a great deal for people who are elderly and people with IDDD, since the former are more likely to have accumulated savings and property that can be exploited. Other Michigan stakeholders reported that the supposedly bolstered procedural safeguards of the IDDD guardianship law were not playing out in practice. For example, the statute was designed to promote partial guardianships over plenary guardianships, with partial guardianships automatically expiring after 5 years. However, in some Michigan counties, stakeholders reported that partial guardianships for people with IDDD are never ordered, while in other counties, so-called partial guardianships are so broad as to be, for all intents and purposes, plenary. One advocate described partial guardianship only preserving, for example, a person's right to choose their own clothing. These would seem to suggest that the manner in which guardianships plays out for people with IDDD has little to do with how the actual law is written. On the other hand, stakeholders in New York, who commented on the different nature of the state's IDDD guardianship statute, raised serious concerns about its disparate impact, with one arguing that people with IDDD deserved equal protections under the law, and the other lauding a challenge to it on constitutional grounds. These concerns were forcefully brought to the fore in a 2015 report of the Mental Health Law Committee and the Disability Law Committee of the New York City Bar Association, which unequivocally concluded that the separate New York guardianship law discriminates against persons with intellectual and developmental disabilities, denies procedural and substantive due process to those for whom guardianship is sought, and over whom guardianship is imposed, fails to honor or promote autonomy, self-determination, and dignity, and fails to protect persons under guardianship from abuse, neglect, and exploitation. The New York Olmsted Cabinet made similar conclusions and recommended guardianship reform on the basis of the Americans with Disabilities Act, finding that community integration includes the ability of people with disabilities to make their own choices to maximum extent possible, and that guardianship should consist with olmstead only be imposed if necessary and in the least restrictive manner. Page 42. There are two excerpts at the center of the page. The first one says, New York's highly permissive statute would appear to raise significant concerns as to whether the bodily integrity of persons under guardianship under its provisions is truly respected. Excerpt 2 says, one of the more pertinent questions is whether the separate guardianship schemes for people with IDDD will protect the right of people with IDDD to make important decisions about their health to the same extent as people covered by non-disability specific guardianship statutes. Page 42. Separate statutory guardianship schemes also may raise questions that are relevant to NCD's upcoming report series on bioethics and disabilities. One of the more pertinent questions with respect to bioethics is whether the separate guardianship schemes for people with IDDD will protect the right of people with IDDD to make important decisions about their health to the same extent as people covered by non-disability specific guardianship statutes. Many modern guardianship statutes prohibit the guardian from consenting on behalf of the person under guardianship to certain drastic medical procedures, such as removal of an organ or commitment of the person to a nursing facility or institution. However, only some of the IDDD-specific statutes prohibit guardians appointed under the subsection from making healthcare decisions that could permanently alter the health of the person under guardianship. For example, as noted in Appendix A, Connecticut's IDDD-specific statute prohibits both plenary and limited guardians from removing a bodily organ except in accordance with statutory procedures to save the person's life or protect the person's physical or mental health. New York statute, by contrast, allows the guardian to make any and all healthcare decisions for the person with a disability, if it is in the person's best interest, which would include an organ transplantation or removal. New York's highly permissive statute would appear to raise significant concerns as to whether the bodily integrity of persons under guardianship under its provisions is truly respected. Whether or not a state's disability-specific guardianship statute does, in fact, make it easier to obtain guardianship over a person with IDDD. The fact that some state law has different guardianship standards that apply to this population is concerning, since it still links the removal and transfer of rights to a person's diagnosis. If, as a nation, we are to move away from a diagnosis of medically driven system for guardianship toward the functionality-driven approach that recognizes less restrictive options for all people with disabilities, we need to encourage a more uniform state approach, as endorsed by the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act and the 2018 NCD report. Chapter 4, U.S. Trends in Guardianship Alternatives in People with IDDD. At the center, this excerpt says, the starting point of any major reform is an accurate picture of the policy in need of reform. In this case, that means at a minimum that states are able to count the number of incoming and outgoing adult guardianship in the state courts. Page 43. The guardianship data problem. The 2018 NCD report recognized that national and state data on guardianship itself, let alone the demographics and the type of disabilities of people subject to it, are scant to non-existent. Even identifying the number of active cases or their status is not possible in many states. Record keeping is frequently inconsistent or dated, and most states do not have centralized data collection or tracking systems. The 2018 NCD report recommended that Congress and the administration develop initiatives to produce effective and comprehensive data on guardianship. As one scholar said, the starting point of many major reforms is an accurate picture of the policy in need of reform. In this case, that means at a minimum that states are able to count the number of incoming and outgoing adult guardianship in the state courts. In short, we collect data on issues that are important to us. Guardianship should be one of those issues given its impact on the civil rights of people with disabilities and the impact of their ability to live, work, and participate in the community. This project adopted a two-pronged approach to identify data-supported trends in guardianship and alternatives specific to people with IDDD. First, to turn to National Core Indicator, NCI, data publicly available through the National Association of State Directives of Developmental Disability Services, NASDDDS, and the Human Services Research Institute, HSRI, NCI initiative. This data is the result of surveys across the nation of people with IDDD who receive publicly funded services through the state and includes information about guardianship and life outcome measures. The results of that NCD's examination are summarized in this chapter in Appendix B and C. Second, this project conducted a deep dive analysis of guardianship's impact on people with IDDD within the District of Columbia, the nation's capital, including identifying and analyzing IDDD specific data points that are not yet publicly available in other jurisdictions. The results of that analysis are summarized in Chapter 5. Page 44. Review of National NCI data. National Core Indicators, NCI, website https://www.nationalcoreindicators.org/ are standard measures to assess the outcomes of services provided by public developmental disabilities. Agencies to adults with IDDD indicators address key areas of concern, including employment, rights, service planning, community inclusion, choice, and health and safety. Using the NCI website developed by HSRI and NASDDS, users can generate charts related to specific outcome measures with NCI data from the years 2008 to 2009 through 2015 to 2016. Most importantly, for the purpose of this report, the NCI chart generator can filter data by whether the person has a legal guardian or not. Users can also filter results by race, ethnicity, gender, age, and type of residence, among other key demographics. While not comprehensive of all persons with IDDD in the United States, the NCI data is one of the only sources of nationwide data on people with IDDD and guardianship. NCD used the NCI chart generator to review relevant data from 2008 to 2009 to 2015 to 2016. We also reviewed the NCI in-person survey national reports for 2016 to 2017 and 2017 to 2018, which were published by HSRI and NASDDDS in May 2018 and March 2019, respectively, and include NCI data points that are not available for filtering through the NCI chart generator. NCD's review of this data by state is set forth in Appendix B as a table, which includes the percentage of people with IDDD in guardianship, limited, full, or the scope of which was undetermined, and the NCI average by year from 2008 to 2018. While the District of Columbia and all U.S. states except Iowa, Montana, North Dakota, and West Virginia have participated in the NCI initiative, Alaska, Idaho, and Nebraska did not have guardianship-specific data available through the NCI chart generator. Relevant information relating to the state percentage of guardianships was available for Idaho in the 2016-2017 NCI in-person survey national report, and for Nebraska in 2016 to 2017 and 2017 to 2018 NCI in-person survey national reports. As reflected in Appendix B, trending of NCI data sheds light on the prevalence of guardianship across participating states. The reported percentage of people with IDDD in guardianship, full, limited, or of undetermined scope, varies widely between states. In 2017 to 2018, the highest were Nebraska, 89%. Connecticut 84%, Missouri 82%, Michigan 81%, and North Carolina 75%. And the lowest were Delaware 5%, South Carolina 9%, Georgia 16%, Louisiana 16%, and Pennsylvania 18%. In 2017 to 2018, most people with IDDD surveyed in 20 of 36 participating jurisdictions, including in the 2017 to 2018 NCI in-person survey national report that year, had guardians. The overall average of state percentages of people with IDDD in some form of guardianship has ranged between 45 and 55% annually across the 10 years of NCI data reviewed. The NCI averages of cases of guardianship across participating states range between 43 and 53% annually during that 10-year time period of the 17 states that have NCI data available from both the 2008, 2009, and 2017 to 2018 reporting periods. Most had guardianship percentage increases, some of which were relatively small. For example, Alabama 1%, South Carolina 2%, Ohio 6%, Pennsylvania 6%, and others that were more significant. For example, New York 10%, Wyoming 11%, Arkansas 12%, North Carolina 12%, Connecticut 14%, and Indiana 19%. Page 45. 3 states, Louisiana, Missouri, and Oklahoma, had no change in the percentage of people with IDDD in guardianships in 2008 to 2009 compared to the percentage in 2017 to 2018. 5 states had decreases in the percentage of people with IDDD in guardianship, 4 of which were relatively modest. For example, Massachusetts, minus 2%, Georgia, minus 5%, Kentucky, minus 8%, and Illinois, minus 8%. Based solely on those 2 years' worth of NCI data, Delaware had the most significant decrease, minus 24%. Based on the individual states' averages, when a person is in guardianship, most are full guardianships. Only California and the District of Columbia regularly had more limited guardianships than full guardianships. However, that trend changed for the District of Columbia in the years 2016 to 2017 and 2017 to 2018, when the percentage of full guardianships became slightly higher than limited ones. Percentage of people with IDDD in limited or full guardianship. In 2015 to 2016, the highest percentages of people with IDDD in limited or full guardianship were Connecticut 83%, Missouri 80%, Maine 77%, Vermont 77%. And the lowest percentages of people with IDDD in limited or full guardianship were Louisiana 13%, Georgia 16%, Pennsylvania 18%. In terms of the 5 states that apply entirely separate guardianship statutes to people with IDDD, 2 were well under the overall state average percentage of 49%, namely California, overall annual average of 23%, and New York, overall annual average of 32%. The other 3, namely Idaho, overall annual average of 58%, Michigan, overall annual average of 76%, and Connecticut, overall annual mean of 80%, were well above that overall state average. This suggests that whether a person with IDDD is under guardianship may have very little to do with the type of guardianship law that is applied to them. Appendix C tabulates additional NCI guardianship data by gender and race ethnicity and was developed by NCD through the use of the NCI chart generator, which is currently limited to data from 2008 to 2009 through 2015 to 2016. NCD's review of that data indicates that there is no significant difference between the percentage of male and female participants who have guardians, annual average 48% versus 49%. But the percentage of people with IDDD who have guardians was highly variable by race and ethnicity. Page 46. There are two excerpts. The percentage of people with IDDD who have guardians was highly variable by race and ethnicity. First excerpt. Second excerpt. Based on the new 2015-2016 NCI average, 18 to 22-year-olds were the most likely of all the age groups that year to be in guardianship, 58%. Page 46. There is no significant difference between the percentage of male and female participants who have guardians, annual average 48% versus 49%, but the percentage of people with IDDD who have guardians was highly variable by race and ethnicity. After this report was nearly completed in April 2019, NASDDDS and HSRI, in partnership with the University of Missouri, Kansas City, released a report. What do NCI data reveal about the guardianship statutes of people with IDD? NASDDDSHSRI-UMKC report. This report included an analysis of new data from the NCI 2017 to 2018 in-person survey national report, which was published in March 2019 and includes data not currently available through the public NCI chart generator, and raised resulting policy questions as well as promising practices, among other findings. The NASDDDSHSRIUMKC report analyzed the demographics of people with IDDD surveyed. Based on the guardianship status, findings trended by race included people with IDDD surveyed who are white were significantly more likely to be in guardianship, 46.4%, than people who were Black, 34.2%, or Hispanic, 26.3%. People with IDDD surveyed who are Black and have a guardianship were significantly more likely to have a public guardian or public administrator as a guardian, 18.4%, than people who are white, 11.2%, or Hispanic, 4.3%. People with IDDD surveyed who are Hispanic were significantly more likely to have a family member as guardian, 91.1%, than people who are Black, 71.6%, or white, 81.6%. Appendix C also has additional NCI guardianship data by age. For example, from 2008 to 2016, roughly 50% of people with IDDD between ages 18 to 74 had guardians, and this did not vary much between the ages of 18 to 34-year-olds, 50%. 35 to 54-year-olds, 48%, and 55 to 74-year-olds, 48%. Based on the annual average, people with IDDD who are 75 years or older were more likely not to have a guardian, 71%. For its 2015 to 2016 data collection, the NCI initiative broke down the 18 to 34-year-old category into two subcategories, 18 to 22-year-olds and 23 to 34-year-olds. Based on the 2015 to 2016 NCI average, 18 to 22-year-olds were the most likely of all the age groups that year to be in guardianship, 58%. In addition, the 2015 to 2016 NCI average percentage of people with IDDD, 75-year-olds or older without guardianship, 52%, was notably lower than the 2008 to 2015 NCI average, 71%. Page 47. The excerpt at the center says, NCI data, however, does not always provide a complete picture of guardianship. Each state participating in the NCI initiative decides what population of people with IDDD it surveys, and most do not survey all people with IDDD in the state. Page 47. NCI data, however, does not necessarily provide a complete picture of guardianship for people with IDDD in all the participating states. For example, based solely on NCI data, Missouri has consistently been the state with one of the highest percentage of people with IDDD under guardianships, ranging from 80% in 2015 to 2016 and 2016 to 2017 to 87% in 2009 to 2010 and 2013 to 2014. However, each state participating in the NCI initiative decides what population of people with IDDD it surveys, and most do not survey all people with IDDD in the state. According to stakeholder interviews, Missouri conducted NCI surveys of people with IDDD receiving individualized supported living and residential services. Therefore, If some people with IDDD in Missouri receive different services, such as individual supports, self-direction services, or employment services, or no services, they would not be included as part of the NCI data set. To obtain a clearer picture of guardianship data, in September 2018, the Missouri Department of Mental Health's Division of Developmental Disabilities conducted an initial data analysis of all its Medicaid HCBS developmental disabilities waivers, except for autism services. It determined that the percentage of people with IDDD served under these waivers who had guardians and/or conservators was approximately 50%, which is much lower than indicated by NCI data. In addition, some states may have existing NCI data relevant to guardianship that is not within the NCI chart generator or the in-person survey, national reports. For example, Alaska was one of the states for which guardianship-specific data is not included in either of those resources. However, the 2015-2016 Alaska NCI Adult Family Survey final report indicates that 100% of the family members with IDDD are under limited or full guardianship, and 96% of these individuals are under full guardianship. Based on stakeholder interviews, that startling statistic is far above that of any of the states listed in Appendix B and reportedly led local advocates to push for legislation, making Alaska the first state to allow people with guardians to execute SDM agreements with the permission of their guardians. The reported reasoning was that Alaska should not leave such a state percentage of people with IDDD behind in its reform efforts to recognize and promote decision-making rights. In addition, SDM agreements of this kind may serve as a gateway for people to work with their guardians toward rights, restoration, and greater independence. Even with the acknowledgement of its limitations, NCI data can provide indicia of the possible impact of guardianship in the lives of people with IDDD. For example, the NASDDDS-HSRI-UMKC report analyzed outcomes for people with IDDD with and without guardians based on the most recent 2017-2018 NCI data. Page 48. The excerpt at the center says, any NCI data correlation between guardianship and institutionalization does not get to the core question of whether it is guardianship itself that led to the person living in a more restrictive residential environment. Page 48. The report found that NCI respondents without guardians are less likely to live in their own homes or apartments, be included in the community, have their rights respected, have community jobs or service plans with that goal, be supported to communicate with friends, go on dates or marry, and be involved in making choices about their own lives. For example, where and with whom to live, who their support staff or case managers are, what their schedule looks like, what to do during their free time or during the day, and what to buy with spending money. NCI data also can be used to explore whether or not people with IDDD who have guardians are more or less likely to live in restrictive environments than those who do not. Scholars have disagreed as to whether people with guardians are predisposed or disproportionately subject to institutionalization. Some argue that they are, pointing to studies done of residential decisions made by a sample of state public guardianship programs. Others disagree, citing studies indicating that guardianship may delay institutionalization, although ultimately not prevent it. NCI data indicates that the answer to this question may be more nuanced for people with IDDD. In the NASDDDS-HSRI-UMKC report, the most recent 2017-2018 NCI data indicated that NCI respondents in guardianship were significantly more likely to live in group residential facilities and less likely to live in their own home or apartment. However, that report also found that respondents in guardianship were not more or less likely to live in an ICF-IDD nursing facility or other institutional setting than those who were not under guardianship, which is contrary what NCD found with an older 2015 to 2016 NCI data. See Table 6 of Appendix C. Ultimately, any NCI data correlation between guardianship and institutionalization does not get to the core question of whether it is guardianship itself that led to the person living in a more restrictive residential environment. The answer is more complicated than that and likely dependent on other factors such as whether a state service delivery systems or supports appropriately promotes community living for people with disabilities.